2025. You're charged with the state jail felony offense of driving while intoxicated with a child under 15, and that's from July 3rd of 2020.
All right. Pause for a second before we even hear the charge. Anytime a case involves drunk driving with a child, I'm already bracing myself, because the law treats that differently for a reason. This isn't just about bad judgment. This is about putting someone who couldn't protect themselves directly in danger.
Good morning, sir. Are you John Roy?
Yes, ma'am.
And Mr. Stringfellow, will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Roy, in cause number 25, DCCR 1365, you're charged with the state jail felony offense of driving while intoxicated with a child under 15, and that's from July 3rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Stringfellow? Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you...
He pleads guilty. No trial. No fighting it. And that usually means one of two things. Either the evidence is overwhelming, or the plea deal is good enough that it's not worth the risk.
Agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal. And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated for 4 years. You would be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1, Mr. Stringfellow.
Yes, ma'am. No objections.
It's admitted. Is there any evidence that Mr. Roy is not competent? All right, Mr. Roy, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report.
A couple of things, Judge. The agreement contemplated an interlock device. I don't know if we put that in the paperwork. And another thing, Judge, I don't know if the court would entertain, Mr. Stringfield and I talked about this, maybe waiving appeals in this case.
Okay, let me, can you send me that paperwork back, Anna, and I'll write, that's your agreement, is that he would have an auto ignition interlock device
Yes,
on
ma'am.
any vehicle he drove?
Yes, ma'am.
And here it is. 2 years in state jail. Probated. 4 years probation. That means no immediate jail time. If you're wondering why people react so strongly to these cases, this is why. A child was in the car, and the sentence lives mostly on paper.
No history that you
Judge,
can,
the state's file reflects a 1994 operating a vehicle by intoxication. That's out of the state of Louisiana. And a couple of arrests, an arrest for battery in 2008, another arrest for battery in 2019. Other than that, no other criminal history. My understanding is that the defendant is from Louisiana.
Yes, he resides in Louisiana.
okay. So, with everyone's permission first, can I make that right in on that agreed punishment recommendation page, the agreement for the auto ignition interlock device?
No objection.
No objections.
All right.
This
So
part really matters. The court has no real criminal history, but listen closely. A prior intoxication offense, multiple battery arrests. They are older, yes, but they paint a picture. Patterns don't disappear just because time passes.
So then what I'm going to do, Mr. Roy, based on Mr. Coleman's representations with regard to any real lack of criminal history, is waive the pre-sentence report. So again, make that finding that you entered that plea freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of the state jail felony offense of driving while intoxicated with a child passenger. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but I'm going to probate that, so you're on probation for 4 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes having the auto ignition interlock device on any vehicle that you drive. You cannot drive a vehicle unless it has that. You'll talk to probation today here in the courtroom. She'll probably send you over to the probation office at some point. It's important you give them all the information of where you live so that they can work on the proper process of getting your probation transferred over where you are, okay? I'm handing you now the trial court certification. That shows this was...
This is the turning point. The judge accepts the deal, waives the pre-sentence report, and officially puts him on probation. And I want to be clear, plea deals are legal, they are common, and judges rely on them. But emotionally, this is where viewers split. Some hear second chance. Others hear missed accountability.
This was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney. All right? Good luck to you, sir. Make sure you stop and talk to probation. She might be ready for you now. She might have you have a seat and then visit with you. Yes,
The
sir.
firearm warning is standard, but then comes that line, "Good luck to you, sir." And it lands strangely. Because luck is what you wish someone starting a new job, not someone who drove drunk with a child in the car.
Yes, sir.
He currently has a portable device. Do you think it's possible for him to keep that device instead of installing the permanent machine into his vehicle?
Mr. Coleman, what's the state's position with regard to the portable?
Not necessarily opposed to that, Judge.
Is it it's not required on the state jail felony for him to have, for me to make a finding on the auto ignition interlock. It's not. Okay, so what I will do is have probation place, if he has the portable, he doesn't have to have the auto ignition. If there's any issues at all with missing portable, if you miss blowing or it's whatever happens with that, number one, it could be a violation of your probation, or it could require maybe having both or whatever it's going to take for me to feel like you're safe out there on the road. But keep doing the portable for now. I'll take away that interlock requirement unless there's some issue that comes up that makes me feel like that would be necessary.
Thank you.
All right. Yes, sir. So stop and talk to probation. She'll let you know you probably need to have a seat after that for a few minutes. All right.
Thank you, Judge.
And then the court loosens the ignition interlock requirement. Not removes accountability, but softens it. Portable device instead of a fixed interlock. And the judge explains why. Safety, monitoring, flexibility. But here's the uncomfortable truth. Every safeguard removed is a gamble. And when children are involved, the margin for error should be zero. This case isn't loud. It isn't dramatic. And that's what makes it unsettling. Because justice here doesn't look like outrage. It looks like paperwork, calm voices, and a man walking out instead of being taken in.
Morgan, Shay Morgan, come up, please, ma'am. All right, ma'am, you're Shay Morgan. And Ms. Morgan's charged with theft of property and cause number 24 DCCR 2102. Mr. Kurtz.
We have an offer for resolution in the case. Ms. Morgan has indicated initially that she wants to go to trial, but she's got a number of things that she wants me to look at in terms of evidence. She wants me to present to the state prior to rejecting the very, I think, reasonable offer that the state is making, or the reasonable option that the state
So
is
here's the
giving us.
thing, Ms. Morgan, I'm going to address you on this. Mr. Gertz has been your attorney for over 6 months now. So if there's information that you think is important, you should have been getting that to him 5 months ago. So I'm going to reset the case one more time. This is the last reset. So whatever information you need or get to him or think is important, get that to him so he can get it to Ms. Malfino. And at the next court date, if there's a resolution, great. If not, then we'll get it moved to the trial docket.
Okay, thank you,
Okay?
Judge.
All right, you're free to go. Mr. Cracknell, you're charged in cause number 22-39948 with a second-degree felony. I'm sorry. The state has elected to proceed on the lesser offense of a Class A misdemeanor, solicitation of prostitution, under Section 43.02. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
and because you did what they've charged you with.
Yes, ma'am.
And so I'm going to, just to make sure, based on our previous discussions, the charge is from 2021, and the law that would be in place at that time would be from the code, I guess, that we have dated 19 and 20, where there's been some changes in the level of the offenses of solicitation of prostitution, and the lesser included offense at that time of solicitation of prostitution, well, the offense of solicitation of prostitution at that time was a Class A misdemeanor, which is why that is what we are referring to and pleading to at this time, which is a lesser of the offense that he's been charged with, which is for a child under 15. Correct, everyone?
Under 18, but
Under
yes.
18, I'm sorry.
Yes, that's
Same.
correct.
Okay. And so, Mr. Cracknell, I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year deferred probation, so you'd be on probation for 2 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State Tenors Number 1,
Judge, we have no objection.
it's admitted. Is there any evidence that Mr. Cracknell is not competent?
No, Judge, but can I put something on the record about
Sure,
that, please?
of course.
Mr. Cracknell's father is here with him. The court, a different court, has appointed him as his guardian, as Chad's guardian, in part because of some mental health limitations that he has. He's competent, he's lucid, he understands what I'm talking about. But I've also discussed all of this with his father, who's his guardian, and he understands everything that we've talked about. He understands what the offer is, he understands what the potential consequences are, and we thoroughly discussed it with Chad. He understands how serious this is. He understands that the court can put him in jail up to a year if he violates his probation. And one of the reasons we're doing this, and his father and I have agreed to this offer that we think is a very good offer from the state, is that for the last 4.5, 5 years that Chad's been out on bond, he's been doing everything that the court has ordered him to do. And so we feel confident in his ability to follow the court's rules on probation.
Could have had probation done and over with without all the legal wrangling. But anyway, thank you for that,
I've been
Mr.
asking for a while,
Gertz.
Judge. I've been asking for a while.
And thank you, sir, for being here. And just for the record, your name is?
John Cracknell.
And Mr. Cracknell, you've gone over all of this with Mr.
Yes.
Gertz, like he said, and with your said Chad, and understand and believe that he also understands everything that he's signing, understands what the consequences are with the probation, and if he violates it.
Yes.
Thank you, sir. All right. Then, is there any reason to get a pre-sentence report?
No, Judge.
All right, so Mr. Cracknell, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to waive the pre-sentence report, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a conviction on your record. And if you successfully complete the probation, the case will actually be dismissed at the end. You'll never have this conviction. The other side of that, though, is if you violate any condition of probation, you don't follow the rules with probation, you can come back to court, I can find you guilty, and you could go to the county jail for up to 1 year. Do you understand?
Yes, ma'am.
All right, then, I'm going to hand you, oops, let me get that printed.
I got it filled out.
Okay, thank you.
I'm going to hand you the trial court certification in just a minute that shows this was an agreement that I followed, so you waived any right to appeal. And then you'll just need to have a seat as soon as I hand that to you. You can have a seat here in the courtroom, and the lady that's at that desk right there is with probation. She'll call you up when she's ready to go over all of your paperwork.
Okay.
All right, good luck to you, sir. Thank you, sir.
Thank you.
Thank you, Mr. Gertz. Here's your, Mr. Gertz, there's your,
Thank you, Judge.
thank you. And then we'll figure out, Ms. Werner, I'll help you do whatever we need, whoever we need to contact to figure that out, because,
Thank you, Judge.
okay.
I appreciate it.
Yes, sir. Thank you.
Do we have any sense of what, I was expecting to go on Hatcher next week, all of a sudden that's not a thing. What is, realistically, what does next week look like?
Next week, hopefully it's Miss Perazzo and Tommy is gonna be, they're gonna be up. So we've got, it's a master word one and,
Okay,
yeah, it's old. So that will be my number one. I don't know what will be after that.
okay.
Probably,
Even though Jackson looks serious, nobody got hurt, it's just kind of threatening with a gun.
yeah,
Just
the
like-
age of it,
I know.
could put it up there. So, as my number two potentially. So I'll let you know tomorrow.
Okay,
Okay,
I appreciate it.
sure.
Have a great day. See
You too.
later. That's
Yes,
all I
sir.
have to think with you.
Yep, that's it.
Appreciate it.
Yes, ma'am. Sure.
Mr. Spice, we're speaking, can the court not hold off on sending him to IFS? I think it would be more in the interest of justice. I think if he gets transferred to either Fort Bend or Harris County, I think he'll be in a position to, I don't represent him in Fort Bend, but I know in the Harris County cases.
What do you mean not hold off on it? I can't send him.
Oh, you
If
cannot
he has a
send him-
case pending, I cannot. They won't take him. So he's gonna have to get those cases resolved. They won't take them with a case pending at ISF. So what we'll just need to know, once there's holds on them from those counties, we'll just release our hold
Okay,
to let them get out of here, and then we'll put our hold back on them so that when he's finished with those, we can get them to ISF.
gotcha. Okay.
Again, if that takes months and months and months,
Right.
then
That
we
was
can,
my
it could,
fear.
yeah. If it
The
does,
Harris
get,
ones are crazy.
okay, get with us. If we're looking at least, I would say, if we start getting to 4 or 5 months, let me know, because that's more than the time that he would be spending in ISF, and I would consider that maybe as a sanction, and then get him out and get him in an intensive outpatient.
Okay,
But let's just see where we get from now.
thank you, Judge.
Okay, thanks.